Hi, my name is David Sampedro. I'm a board-certified civil trial lawyer at Panter, and Sampedro. We handle personal injury cases, wrongful death matters involving auto accidents, premises liability, medical malpractice cases. And oftentimes we're asked to bring a claim on behalf of a minor, somebody who is under the age of 18 years, to bring a claim on their behalf because they've been injured as a result of somebody else's or another company's negligence or irresponsibility. What are the circumstances that you can bring a claim and who can bring a claim on behalf of a minor? And what do you have to do at the conclusion of the case? And I'm going to try to address a couple of those issues. Well, a minor does not have the ability or what they call a legal standing to bring a claim on their own. Therefore, they need to have either a natural guardian, such as a parent, or a guardian that is appointed by the court if a parent is not able or willing to do so, to bring the case on their behalf. At the conclusion of the case, and if the case is resolved, there are some circumstances where even if a lawsuit is not filed, that one needs to go to court to get the settlement approved. Let me talk to you a little bit about those circumstances. If the net tort recovery, that is to say the net recovery to the minor, after the deductions for attorney's fees and costs, medical expenses, and things of that nature, is less than $15,000, then you do not need to have a guardianship appointed. If it's in excess of $15,000, in other words, if the minor is going to receive more than $15,000, then the court needs to approve the settlement and a guardianship needs to be appointed as well. And the reason for that is to protect the minor, to make sure that the funds that are received are used on behalf of and in the best interest of the minor, and that the funds aren't used for some type of inappropriate use, whether it's intentional or unintentional. So it's really done to protect the minor from everybody. In situations that the settlement is in excess, as I said, of $15,000 in net settlement proceeds, the court has a discretion to appoint what's called a guardian ad litem, that is an independent person that is appointed by the court to say whether the settlement is in the best interest of the minor. In situations that the gross settlement is in excess of $50,000, in other words, that the total proceeds of the lawsuit are in excess of $50,000, then the court requires a guardian ad litem, again, an independent person who's appointed by the court to take a look at the facts of the lawsuit, the injuries, all of the things that were in favor of the lawsuit and all the negatives of the lawsuit, to make sure that the settlement or that the outcome was in the best interest of the minor as well. There are some things that one can do to try to avoid these additional expenses, because quite frankly, most of these guardianships do require additional time and expenses with the court. A separate attorney under some circumstances may have to be hired, and there are ways to be creative to try to avoid this in a legal way and with court approval. But if the minor receives the funds after their 18th birthday, under some circumstances, you may be able to avoid some of these expenses. So thank you for your time, and have a great one.